SwayamPrabha. Digital India. Educated India.
Hello everyone, welcome to the last lecture of our course on law of copyright, patent, trademark and other IP. In these 19 lectures, you have learnt about the basics of copyright. We devoted few lectures on patent law. We devoted 4 lectures on trademark, and I plan to devote 2 lectures on other forms of IPR, out of which the 19th lecture was on Protection of Plant Varieties and Farmers' Rights Act, which is a sui generis law. I said that it is an effective sui generis law, and Indian law is TRIPS compliant. So whether it is Copyright Act 1957, Patent Act 1970, Trademarks Act 1999, Protection of Plant Varieties and Farmers' Rights Act 2001, all of these legislations are TRIPS compliant. The amendments have been done. Patent Act was amended in 1999, 2002, 2005 so as to make it in line with TRIPS agreement. We had a Trademark Act of Trade and Merchandise Mark Act of 1958, but so as to make it TRIPS compliant, we enacted a new law in 1999. Because TRIPS agreement gives us a grace period of 10 years. WTO became effective from 1st January 1995 for all the developed countries, and for developing countries a grace period of 10 years was granted. So on 1st January 2005, my laws had to become TRIPS compliant, and therefore we modified laws, we enacted new laws. In the same series, in the year 1999, we enacted Geographical Indications Act. In the year 2000, we enacted the law for protection of industrial designs. All these for the purposes of converting the laws or enacting the laws which are TRIPS compliant, because we are the founder members of WTO. Now, in this last lecture, I will be talking about 2 other forms of IPR. One is geographical indications. We will refer to the provision of TRIPS agreement also. The other is industrial design, and this will complete our discussion on the course of law of copyright, patent, trademarks and other IP. So let us start with the first one, that is geographical indications. You see, geographical indications are signs which identify goods as originating from a particular territory. The definition, as you can see here, is GIs are signs which identify a good as originating in the territory of a particular country or a region or locality in that country, where a given quality, reputation or other characteristic of the good is essentially attributable to its geographical origin. So there are certain key words. We are talking about goods which originate in some territory, and it has those qualities, it has got those qualities or reputation or other characteristics because of the specific geographical conditions maybe, or because of specific manufacturing process prevalent in that geographical region. So these are essentially signs and links, signs and indications. Now these can be linked to a particular territory. For example, you have Banarsi saris, or at times even non-geographical names can also be GI if those names are linked to a particular place. For example, basmati rice. The term basmati, of course, we all know is not a geographical place on earth, but this is related to a particular geographical region, the Tarai region of Himalaya, maybe Dehradun region near that place. So, it is not that GI will always be a geographical name. Even non-geographical names can also be GI if those names are linked to a particular place. Now, I have identified the conditions for recognition of a sign as a geographical indication, when a sign becomes a geographical indication. First is, it must relate to goods or services. Second, these goods must originate from a defined area. And third, the most important, the qualities of goods, the reputation of those goods and other characteristics of those goods are linked to the geographical origin of those goods. It has those qualities, it has those characteristics because of the specific geographical location, the climatic condition maybe, or maybe because of specific manufacturing process prevalent in that place. So, this is the basic idea about geographical indication. So, it identifies the origin of the goods. GIs point to a specific place or region of production that confers particular characteristics and quality on the product, as I mentioned. GIs are pointing towards a specific place, a specific region, and the characteristics are because of those region, those places. The connection between goods and place becomes so famous that any reference to the place reminds the goods being produced there and vice versa. Let us take the example of Champagne. Champagne is a district in France where large number of families are manufacturing sparkling white wine. Now, when you look at the sparkling white wine, you relate it to the Champagne district, or vice versa. When you hear this word Champagne, you do not think about a district in France, you think about that sparkling white wine. That is what I mean by saying that the connection between the goods and place becomes so famous that any reference to the place reminds the goods being produced there and vice versa. So, this is the broad meaning of geographical indication. Originally, like any other forms of IP, originally geographical indications were protected according to the national laws. But as we started realizing that misappropriation is taking place internationally, as we started realizing that with the expansion of commerce in the 19th century, national protections proved to be insufficient because much of violation of geographical indication used to take place countries outside my country. So, therefore, people started thinking about a multilateral platform for protection of geographical indications. And one such multilateral platform, the first effort to adopt a common approach to develop a multilateral platform was in the form of Paris Convention of 1883. It relates to industrial property. I think I have mentioned it in one of the lectures that internationally first initiatives came in the form of Berne Convention of 1883 for copyright and Berne Convention of 1886 for copyright and Paris Convention of 1883 for industrial property. GI happens to be one of the industrial property. So, the first systematic effort to adopt a common approach can be seen in the form of Paris Convention 1883. It included indications of source or appellations of origin as the subject matter of protection. So, we did not talk about geographical indications as geographical indications. We talked about GI as indications of source, those words which indicate the source of goods, or appellations of origin. These were the subject of protection. Now, you see Article 10 of Paris Convention does mention appellations of origin expressly. However, they covered the term indications of source as all appellations of origin, and this was the subject matter of protection in Paris Convention, as I mentioned. So, the first effort was Paris Convention 1883, which included indications of source or appellations of origin. Then we also came out with certain other agreements, for example, the Madrid Agreement of 1891 and the Lisbon Agreement of 1958. The Madrid Agreement of 1891 was the first multilateral agreement to provide specific rules for the repression of false and deceptive indications of source. We will talk about these words later on: false indication of source, deceptive indication of source, false GI, deceptive GI. Now, Madrid Agreement was the first multilateral agreement to provide specific rules for repression of false and deceptive indications of source. Lisbon Agreement also stands for protection of appellations of origin. There are two basic requirements for an appellation of origin to be protected in accordance with the terms of the Lisbon Agreement. There are two basic requirements. These are: first, the appellation of origin should be protected in its country of origin. So, therefore, protect the appellations of origin locally before you claim protection globally. That was the idea. The first requirement for protection of appellation of origin was that it should be protected in its country of origin, and second, the appellation of origin should be registered in the International Register of WIPO. It should be registered in the International Register of WIPO. So, these were the two conditions subject to which protection to appellation of origin was granted in Lisbon Agreement. These were some of the initial efforts to give protection to appellations of origin, and finally, in TRIPS Agreement, we recognized geographical indication as a form of intellectual property formally, and we provided for mechanism for protection of GI. Article 22 of TRIPS Agreement provides a definition of geographical indication, and if you see, geographical indications are indications which identify a good as originating in the territory of a member or a region or locality in that territory, where a given quality, and I have mentioned this word reputation in bold, if you see, where a given quality, reputation or other characteristic of the good is essentially attributable to its geographical origin. So, these are goods originating in the territory of a member or a region or locality in that country, where the quality, reputation and other characteristics of the goods is essentially attributable to its geographical origin. The quality is attributable to geographical origin. The quality is attributable to geographical origin. These are the key words. So, what this definition does, it expands the meaning of geographical indication or appellation of origin as given in Article 2 of Lisbon Agreement on the basis of the term reputation, because the definition of appellation of origin contained in Article 2 of Lisbon Agreement only talked about quality and other characteristics of the good essentially attributable to geographical origin, whereas the TRIPS Agreement expands the concept to protect goods which merely derive a reputation from their place of origin without possessing a given quality or other characteristics which are due to that place. It is not that my product is getting its quality because of climatic conditions prevailing in that territory, or it is not that my goods are getting those characteristics because some manufacturing process prevailing in that territory. It is only that my goods have reputation by virtue of the fact that these are originating from that place. Even in those situations, the GIs are protectable. This is what TRIPS agreement does, and that is how the definition of GI, geographical indication, is expanded as compared to Article 2, appellations of origin as defined in Lisbon Agreement. I said in order to be protected, GI has to be a sign, it has to be an indication. It has to be an indication. But I mentioned, as I mentioned before, it need not be a geographical name always. It can be some other word. For example, basmati, for example, pashmina, these are not geographical names, but these are still registered GIs. If you go in detail of TRIPS agreement to see how protection is granted, there are distinctions made in TRIPS agreement for the purposes of granting protection. You have heightened protection in cases of wines and spirits. TRIPS classifies it into 3 parts: the geographical indications relating to all products, geographical indications for wines and spirits, and geographical indication for wines only. You have heightened protection for the last 2, we will not go in detail of that. With this background, with this international framework, let us see how Indian law on geographical indication is formed, is made. The Indian law on protection of geographical indication is called as the Geographical Indications of Goods, Registration and Protection Act 1999. The Geographical Indications of Goods, Registration and Protection Act 1999, I will call it GI Act for convenience. And first thing is the definition given in GI. As it happens in any other form of IP, you must have observed in all these 19 lectures that in any IP law, the first thing which any IP law does is to identify the subject matter. So, there will be a definition of the subject matter and there will be criteria for protection. So, we will see the 2 here in case of GI also. The definition given is GI is an indication which identifies such goods as agricultural goods, natural goods, manufactured goods. So, when we will talk about GI with respect to goods, we mean 3 kinds of goods: agricultural goods, natural goods, manufactured goods. As originating or manufactured in the territory of country or a region or locality in that territory, where a given quality, reputation, you see we have adopted the definition from TRIPS agreement, where a given quality, reputation or other characteristics of such goods is essentially attributable to its geographical origin. And in case these are manufactured goods, one of the activities of either the production or of processing or preparation of goods concerned takes place in such territory, region or locality as the case may be. So, we can divide it into 2 parts. This part is for natural and agricultural goods, this part is for manufactured goods. In case of agricultural goods, natural goods, the quality, the reputation, the characteristics are attributable to its geographical origin. In case of manufacturing goods, either the production of those goods or processing of those goods or preparation of those goods take place in that territory, that place, that locality, that region. This is the definition of geographical indication in your act. I said it can be name of, it can be geographical or figurative representation, or it can be a combination of both. The basic idea is it will suggest the geographical origin of goods to which it is applied. Whether you use a geographical name or you use some other name which may not be a geographical name, the fact is it must link to a particular geographical region, a particular territory. Even if I use basmati, I know where it is grown. Even if I use pashmina, I know where it is manufactured. So, this is the definition of geographical indication according to your act. There is a fundamental difference between trademark and geographical indication. GI indicates source, trademark also indicates source. How these two are different then? The first difference is trademark is owned by enterprises. There are proprietors, individuals are proprietors. And trademark is used to identify product and services in the market. And trademark distinguishes my goods and services from your goods and services. Trademark links the products, the goods, the services with a particular trader. Whereas a geographical indication never belongs to a particular enterprise, first of all. It is a community IP. Try and understand. Most of the intellectual property which we have discussed, these are proprietary rights. These are owned by individuals, whereas geographical indication is a collective IP. It is never owned by a particular enterprise. It is used by several enterprises at the same time. It is used by several people at the same time, provided that the products for which it is used originated in the geographical area to which the indication refers. So, therefore, trademark establishes a link between goods and the trader. GI establishes the link between goods and the geographical region. Geographical names are usually GIs. Geographical names are usually not trademarks. Trademarks are owned by individual proprietors. GIs are collective IP. Trademark is used to distinguish goods of one trader from the other trader. GI is used to identify the goods originating from a particular region. So, on these aspects, trademark and GI are different. Geographical indications perform three functions. As I said, geographical indication identifies goods originating in a particular territory. The first function is that geographical indication identifies goods originating in a particular territory. Goods have quality attributable to their geographical origin. This is something which GI will tell me. And GI also promotes the goods of producers of a particular area. So, we understand the meaning of geographical indication, we understand how GI is different from trademark. We also understand now the functions performed by geographical indication. Let us see what are registrable GIs, which something which we studied in trademark also. What are registrable marks? Although we do not have a list of registrable marks in Trademarks Act. That was my topic, that was my heading. What we discussed there, we discussed the grounds for refusing the registration. Absolute ground section 9, relative ground section 11. Similarly, section 9 provides me grounds for refusing registration of certain GI. Let us see what are these grounds. A geographical indication, the use of which is likely to deceive or cause confusion, is not registrable. A geographical indication, the use of which is likely to deceive or cause confusion, is not registrable. We understand the meaning of deception, confusion. I said confusion in trademarks, I said the confusion may be visual because of visual similarity, because phonetic similarity. So, confusion may be visual, confusion may be phonetic in nature. There may be contextual confusion as to trade origin. The consumers must not be induced to believe that the goods sold under the GI emanates from the same trade source. So, therefore, any GI, the use of which is likely to deceive or cause confusion, is not registrable. A GI, the use of which would be contrary to any law for the timing in force, is not registrable. A GI which comprises or contains scandalous or obscene matter is not registrable. A GI which comprises or contains any matter likely to hurt the religious susceptibility of any class or section of the citizens of India is not registrable. A GI which is determined to be a generic name or indication of goods and is therefore not or ceased to be protected in their country of origin or which has fallen into disuse in that country is not registrable. Generic names and indications in relation to goods means the names of goods which, although relate to the place or the region where the goods are originally produced or manufactured, has lost its meaning, primary meaning, and has become the common name of such goods and serves as a designation for or indication of kind, nature, type or other properties or characteristics of the goods. This is something similar to what we have studied in trademarks law. A word, although a geographical name, a word, although a geographical word, because of its use may lose its primary meaning as a place on earth and has acquired a secondary meaning denoting, depicting, indicating the quality and characteristic of a particular product. Such words become name of those products instead of remaining a geographical indication indicating the source of origin. So, if a particular GI becomes a generic word indicating the product itself, indicating the goods itself in that particular country, then it will not be registered as a GI in India also. Or if there is a word, if there is a GI which has fallen in disuse in its country, that will not be registered as a GI in India. So, these are not difficult to understand. It must not be obscene, it must not hurt the religious sentiments, it must not be contrary to any law for the timing in force, it must not confusion, it must not cause confusion or deception. This is important. Any GI which has become generic name, any GI which has fallen in disuse in that country is not registrable in India. So, these are the grounds on which registration may be refused. This is another important ground. You see, this is another important ground, a GI which, although literally true as to the territory, region or locality in which the goods originate. There is a GI which is literally true as to the territory, region or locality in which the goods originate, but falsely represents to the persons that the goods originate in another territory, region or locality. Such a GI is not registrable. We need to understand it. This may be the case where a given geographical name exists in two different places. There is a place called as P in India, there is a place called as P in some other neighboring country. But and the product is, there is some, there are some goods, there is a good. This P actually is the GI. So, my goods, if originating at this place, I can use this name as my GI. What am I doing? I am manufacturing goods here and I am using this P as my GI. This is literally true because my goods are originating in this territory, but I falsely represent to the people that the goods are originating from this place. So, I hope you understand that such a situation will arise where a given geographical name exists in two different countries, but was used as an indication of source only for product originating from the place in one country. Only this is GI. Use of that indication by producers from other country cannot be regarded as use of false geographical indications. This is not false. This is not false because I am using the true name, literally true name. But then the problem is consumers may be deceived by such use. If that is the case, the GI will not be registered in India. So, section 9 gives me instances or grounds for refusing registration of a geographical indication in India. And once the geographical indication is registered, section 21 tells me the effect of registration. The effect of registration is the rights which we acquire. What are the rights? To the registered proprietor and the authorized user or users, the right to obtain relief in respect of infringement. So, the proprietor and the users of GI can file for infringement. This is the first right which you get after registration. And second right which you get after registration, authorized users get an exclusive right to use the GI in relation to goods in respect of which it is registered. So, right to use is given to users and right to file for infringement is given to users as well as registered proprietors. Now, we have the remedies for infringement of geographical indication. The remedies are civil remedies, criminal remedies. We have discussed the civil remedies in relation to other legislations also, Patent Act, Trademark Act, Copyright Act. Let us quickly rush through these once again. The civil remedies include, first of all, injunction. We understand what are the various kinds of injunction: permanent injunction, interlocutory injunction. There are certain specific forms of injunction like enten pillar order, like Mareva injunction. The second is damages or account of profit. We understand that damages are commensurate to the loss, and account of profit is the profit earned by the defendant. The court shall not award relief by way of compensation other than nominal damages or accounts of profit to the plaintiff in any case where the defendant satisfies the court in the infringement proceedings that he was ignorant at the time he started to use the geographical sign, and he had no reason to believe that plaintiff's geographical sign was on the registry. So, innocent infringement is given some space here. Exemplary damages, damages or account of profit, except for nominal damages of course, will not be paid if the defendant can prove that he was ignorant at the time when he started using the geographical sign, or he had no reason to believe that this geographical sign was on the registry. And when he became aware, of the existence of rights of the plaintiff, he immediately stopped the use of GI for the benefit for which it was registered. So, therefore, only nominal damages will be paid in this situation. The third is delivery up of infringing labels and indications. These are the civil remedies which we have in the Act. The offences which are there, which have been defined, are falsifying and falsely applying geographical indications to goods, selling goods to which false geographical indication is applied, falsely representing a geographical indication as registered, improperly describing a place of business as connected with the geographical indications registry, falsification of entries in the registry. All these are offences. The punishment is imprisonment for a term of 6 months, which may extend to 3 years, a fine not less than 50,000, but it may extend to rupees 2 lakh also. So, these are some of the remedies which we have in the Act and the offences which have been defined in the Act. So, we understood geographical indication, we understand the meaning, we understand the grounds for refusing registration. We also understand what are the remedies, what are the offences. Now, that is all in geographical indication. Let us go to the next legislation, that is industrial designs. Industrial designs, we have a law of the year 2000. Let us first of all understand the meaning of this term industrial design. Industrial design consists of two-dimensional figures such as lines, colors, patterns of an article. Now, this is different from trademark. We are not talking about packaging, we are talking about the article, the goods. So, industrial design can be two-dimensional such as lines, colors, patterns of an article. It may be three-dimensional such as shape of an article. So, what we are going to discuss now is not how the product is packaged. We are now going to talk about how the product looks. We are not going to talk about how the product works, that will be patent law. How the product works would mean what is that invention, what is the working, what is the protection, the functional part of a product will be protected by patent law. The packaging of the product will be protected by trademark law. We are not talking about how the product works, we are talking about how the product looks, appearance of the product. Because appearance, the aesthetic aspect of the product adds tremendous value to the product. And that aesthetic aspect must be protected, and for that purpose only the Designs Act 2000 has been enacted. Article 25, clause 1 of TRIPS agreement provides that members shall provide for the protection of independently created industrial designs that are new or original. So, the criteria is mentioned in Article 25. Industrial designs will be protected if they are new or original. The provision says that, you see, there are certain highlighted parts. The provision says that members may provide that designs are not new or original if they do not significantly differ from known designs or combinations of known design features. So, the design in question must be new or original. What do we mean by novelty? What do we mean by originality here? New and original means significantly different from known designs. Members may provide that such protections shall not extend to designs dictated essentially by technical or functional considerations. An exclusion can be provided. It gives freedom to the members to exclude such designs which are dictated by technical or functional considerations from protection. Article 26, clause 1 provides that the owner of a protected industrial design shall have the right to prevent third parties not having the owner's consent from making, selling or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. So, what all becomes very clear by virtue of Article 26(1) is that the rights of making, selling or importing articles bearing the design, these are exclusive rights of the owners of designs. There are three rights: right to make, right to sell, bearing the design, and right to import articles bearing the design. What do we mean by copying? It can be an identical copy, it can be substantial copy. We have discussed the concept of substantial copying in copyright law, that may help you here sometimes. And it must be done by infringer for commercial purposes. So, this lays down the background in which the Designs Act of 2000 was enacted so as to comply with the requirements of TRIPS agreement. And let us see what is there in Designs Act 2000. Section 2D gives me the meaning of design. It defines a design. Design means the features of design can be the shape, design can be configuration, pattern, ornament, it can be composition of lines, it can be colors applied to an article, and any one of these is to be applied by industrial process. It can be manual process, it can be mechanical process, it can be chemical process. Any of these, the shape, configuration, pattern, ornament, composition of lines, colors, it can be in 2-dimensional form, it can be in 3-dimensional form. All these forming part of the article, such that in the finished article, such that in the end product, these features, the shape, configuration, pattern, ornament, composition of lines, whether 2D or 3D, such features appeal to and are judged by the eye. So, design must be visually appealing, it has no functions to perform. Design must be visually appealing. There are certain exclusions. Any mode or principle of construction is not registrable as design. Anything which in substance is a mere mechanical device is not registrable. A trademark is not registrable. An artistic work is not registrable. To learn more about the interface between copyright, the artistic work, copyright in artistic work and industrial design, you may refer to section 15 of Copyright Act. What are the criteria for registration of an industrial design? A design qualifies for registration only if it is either new or original. It has not been disclosed. We will see what do we mean by disclosure to public. It is distinctive in the sense that it is significantly distinguishable from known designs or combination of known designs. It must not contain scandalous or obscene matter. It must not be contrary to public order morality. So, basically these three are important factors. These are obviously required in all the forms of IP where registration is to be done. Must not be scandalous, must not be obscene, must not be violative of public order, must not be violative of morality. The important things are the design in order to get registration must be new or original. It must not have been disclosed to public, and it is distinguishable from known designs or combination of known designs. Novelty here means that the design is created for the first time and was not known before. Now, there are few points about novelty. We must understand it differently from what we know in patent law or as we discussed in Plant Variety Act. There must be not a mere novelty of outline. There must be substantial novelty in the design. A new design, which is nothing but mixing two old ones, even that can be registered if it results in something new. Mere novelty of form, mere novelty of shape may not be sufficient. The word original may mean a new application of an existing or known design. Original means, this is a different meaning from what we have studied in Copyright Act. The word original means new application of a known design to a new subject matter. So, what I am trying to say, a design may not be new in the sense that it is completely new, but it may be an existing design. It is still registrable if it is original. Try and understand. A design has to be new. Originality means new application of a known design to a new subject matter. So, therefore, what I conclude, a design has to be new, but even if it is not new in the sense that it is not absolutely new, it is still registrable if it is original, if it is a new application of a known design. So, novelty or originality depends on the nature of the design, the nature of the manufactured article to which it is applied, and state of knowledge of the industry producing such article. Now, if you go back, I said it must be new or original. We understand the meaning of novelty, originality here in this context. Second, it has not been disclosed to public. Disclosure or publication of design, what do we mean by that? What all are disclosed if it is previously registered? If the same design or substantially the same design, need not be an identical on all points, but if the same design, substantially same design has already been registered, it is considered as published. Such a design cannot be registered. Second, if the design is published in any tangible form in any country, if it is published in any tangible form in any country, kindly compare it with the prior art which you have studied in patent law. The word published is not defined, but if it is published in any tangible form, the meaning is clear that it is known to public and there is no territorial limit. The idea is it is published if it is no longer a secret. And keep in mind that in order to be called as published or disclosed, the actual use of design is not a requirement. So, a design is disclosed if it is previously registered, a similar design is previously registered. A design is disclosed if it is published in any tangible form anywhere in the world. There is no territorial limit. So, a design is published if it is no longer a secret. But then there are certain disclosures which are excluded, and keep in mind the disclosures which are excluded, which I have discussed in patent law. Certain disclosures are not considered as disclosure. For example, confidential disclosures. If I am disclosing some design under confidentiality clause, then such a disclosure will not mean publication. For example, the acceptance of first and confidential order for articles bearing a new or original textile design which has not been registered so far, it is a confidential disclosure, it does not mean publication. Similarly, if the design is displayed in an exhibition, there are three conditions. Section 21 provisions should extend to such an exhibition. Central government must notify such an exhibition to which the exemption applies. The exhibitor gives previous notice in the prescribed form to the controller, and in case the design is displayed in exhibition, you must file the application for registration within 6 months from exhibition. And if you recall, such a disclosure is exempted in case of patent law also, and the timeline which we have there is 12 months. So, the time given here is just 6 months within which you must file the application. Now, if I go back to the qualifications, we understand new and original, we understand what do we mean by disclosure to public. The third criteria is it must be significantly distinguishable. So, the third is distinctiveness. For a design to be significantly distinguishable from known designs or combination of known designs, there should be significant variation and not merely small and superficial variations. So, in terms of significant variants, my design must be distinguishable from other designs. What qualifies as design? Label as a design. Design is a part and parcel of the article. I said it is part of the finished product. Trademark is something on packaging. Thus, the label which is to be put on the carton can never amount to design. Can carton amount to a design? As I said, registrable design, the designs, registered designs will become part of finished article itself, and carton is not finished article. Therefore, no registration of the drawings, figures or letters on the 5 sides of the carton will be allowed. There is a case of 1964, Thakurdas versus Sardar Trading Company. Petitioner claimed that the respondent's carton, in which numerous shoulder pads could be packed, has identically similar design as are to be found on petitioner's carton. Court held that article in the case was the shoulder pads, and what could be protected under the designs law was any design on the article and not a design on the packaging or the cartons. The third point in what qualifies as design is designs which are mechanical devices are not registrable. Mechanical device is a shape in which all the features are dictated solely by the function which the article has to perform. A design which are mechanical devices are not registrable. For example, design of a matchbox, design of a crane cannot be registered, because the design is dictated solely by the function which the article has to perform. Such a design is not registrable. I want to say that functional features, functional designs are not registrable. Functional features are not registrable as design. We are only talking about those designs which have a distinctive and novel appearance, should not be excluded merely because they also contain features that are dictated by functional requirements. This is important. We said designs which are mechanical devices are not registrable, but there may be a design which has aspects of both aesthetic aspect of the design and functional aspect of the design. So, we will not dismiss it only on the ground that functional aspects are not registrable. Therefore, one has to identify the fundamental form of that article, the essential structure to perform the required function, and then to determine the extent to which that form has been supplemented. The functionality and aesthetics may be found to coexist in some article. We will have to see the dominant effect on the eye. What is more important, the functional part of the design or the aesthetic part of the design? When the purchaser is purchasing the product, is he getting influenced by the functional part of the design, or is he getting influenced by the aesthetic part of the design? So, the dominant aspect test will be applied here. Look at the dominant aspect to decide whether it is registrable or not. The registration of design confers on the registered proprietor copyright in the design, and here this word copyright does not mean copyright as we understand in Copyright Act 1957. Copyright in design is granted for a period of 10 years from the date of registration, and it is extendable by 5 years. I said this copyright in design is different from the copyright which we have understood in Copyright Act. Here the copyright means two things: exclusive right to apply the design to any article, and second is right to file for infringement. So, this exclusive right to apply the design to any article is the meaning of copyright here. What are the rights? The exclusive right to apply the design, the exclusive right to import any article with the design applied to it, the exclusive right to publish or expose articles bearing the design. So, in this lecture, we discussed two forms of intellectual property, the geographical indications and industrial design. My main objective was to tell you the meaning of these two forms of IP and to tell you the criteria for registration and the rights conferred by these two. There are many other aspects as to when these are infringed, what are the remedies which we could have gone in detail, but I am sure with whatever we have discussed so far in this course, you are in a position to look into the bare act and learn other aspects which I have not touched yourself. In this course, we have discussed Some important aspects of copyright law. First of all, I devoted some 8 lectures on copyright law, starting from the subject matter to rights to the ownership. We also identified who is the owner, who is the author. We discussed as to what are the instances of infringement of copyright. In case of infringement of copyright, what are the defenses does a defendant have? We discussed the remedies. We talked about the administration of copyright, the individual administration by assignment license and collective administration by copyright societies. The next 5 lectures were on patent law. In patent law, we discussed the criteria for getting patent. We discussed section 3, which identifies the list of things which are not considered as invention. We talked about procedure to obtain the patent. I devoted 2 lectures on the process, patent prosecution part. We discussed about the processes, the stages of filing, publication, examination of application. We referred to the proceedings of pre-grant opposition, post-grant opposition, and towards the end I discussed about the infringement of patent rights, the aspects of compulsory licensing, which is a public interest provision, and I also talked about revocation, which is another public interest aspect. In all the IP legislations, I have made it clear that rights are the least important provisions. In Trademark Act also, I told you about the meaning of trademark, collective mark, etc. I told you about what are the registrable marks. We discussed about infringement. We tried to understand the difference between infringement of trademark and passing of remedy. And towards the end, I devoted 2 lectures on other forms of IPR. The first one was on Protection of Plant Varieties and Farmers' Rights Act. We discussed various aspects of PPVFR Act, including benefit sharing. I also incidentally referred to Biodiversity Act of 2002. You may refer to that act to learn more about the interface between TRIPS agreement and Convention on Biological Diversity. And in the present lecture, I discussed about GI and Designs Act. With whatever discussions we have done, I am sure you are in a position now to learn more about the subject. Kindly refer to the BEAR Acts to learn more about the subject. So that is all from me on the subject of law of copyright, patent, trademark and other IP. Thank you very much for attending the sessions. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.